I call the honourable member.
He's awake.
Gareth Hughes.
Kia ora, Mr Speaker, na mihi nui kia koutou kia ora. It's a real privilege to stand here and rise and speak on the Copyright Parallel Importing of Films Amendment Bill. Mr Speaker, copyright's an incredibly important issue. It's moved from the arcane, sort of dusty world of the law libraries maybe 10 years ago to something literally changing global politics, and the front pages of our newspapers will say the Kim.com case, changing the representation and the nature of parliaments all around the world with new political ideas coming in, new business models, new jobs being built, and it's good to be debating it in our parliament. But not in the context of this bill, which is a bill the Green Party will be opposing. It's disappointing both the Labour and National parties will be supporting it. When we heard the submissions and the arguments in the Select Committee, I think there was a very compelling argument not to support this bill. But, oh well, the Greens will be opposing. So what this bill does is reinstates the ban on parallel importing of films for 5 months following the film's first release to the public in New Zealand. The rationale is to give distributors and cinemas sufficient times to have the film screened to make the money out of it without the risk of competition. This ban will be in place for 3 years until 2016. Of course, it comes on the back of a 10-year ban, which we're just about at the edge of now. So, no one in this Parliament thinks that we should have this parallel importing ban post-2016. What the Green Party says is let's deal with the issues now. Let's not disadvantage new competitors, new business models emerging in New Zealand. Let's do it now in 2013, not 2016, which every party in this Parliament agrees. So I first want to touch on the process, because what we've seen is an incredibly poor process. As I said, we've had 10 years warning. We've had a 10-year parallel importing ban, which is soon to expire. We've had 10 years warning, yet still the government introduces this legislation under urgency. In fact, the Green Party was considering a letter from Minister Foss in our caucus meeting and inviting us to share our opinions. That afternoon, this legislation was slammed down on the parliamentary table, introduced under urgency. Not a good process at all, because what we should have as a robust consideration of the issues. We were willing to engage with the Minister. We'd like to hear from officials. But when you ram through a bill under urgency, it's an incredibly poor process. And something like this, where we've had 10 years warning, surely isn't adequate to be debated under urgency. That's why the Green Party abstained in the first reading. We didn't have time to talk to submitters. We didn't have time to talk to the public and experts. So that's why we abstained. And I'd like to acknowledge the people that are involved in the Select Committee process. We only had a handful of submitters, but I'd like to acknowledge them. I'd like to acknowledge and thank the Select Committee members and the Chair. And in the Select Committee, we heard the arguments, we heard the submissions, we weighed up the evidence, and that's where the Green Party reached our position to oppose this bill. So when you look at the advice the committee received and say the advice the Minister received in the regulatory impact statement, even officials aren't clear this bill is a good idea, and officials were in fact advising against this legislation, as I pointed out in the first reading speech. Now, there's just no justification to treat cinemas in a special case. Now, I find it rather ironic that the two older parties, apparently talking about free markets and neoliberal economics, who railed against, say, examples of margarine being prohibited versus butter. Well, I'll get to that point in a minute, but the analogy, like this bill is like in the 70s, how New Zealand protected our butter industry by blocking out competitors in statute. It's exactly the same case. It's like how we stopped margarine. This bill is about using statute to protect a temporary monopoly to block out their competitors. And I find it deeply ironic, and the members on the committee know this because of the arguments we had on the committee, that it is ironic that two old parties support this bill. It's just like blocking out margarine to protect the butter industry. We've heard about the digitisation of cinemas argument. Now, the fact is they've had 10 years to prepare, as we know. And if the cinemas can't do it now, they're still going to struggle with the release of, say, children's films, which we heard on the Select Committee in 2016. If they have a trouble now, it's going to be difficult to see success there. Now, I want to touch to the member point, which is the Green Party loves cinemas. I personally love cinemas. There's some fantastic cinemas around New Zealand, and they compete not because they have a statutory monopoly of the rights to a material, disadvantaging competitors. They do it because they got good quality facilities. They do it because they provide a great service. They don't compete because they have lawmakers and the ability to lobby to try and get a temporary statutory protection of the material, disadvantaging their competitors. So what we see is just another example of this government doing special deals for their mates. Now, we've seen this government put aside their so-called principles when it comes to economics, when it comes to TY. We saw the Prime Minister literally pick up the phone and give $30 million when we had TY bend the government over a barrel because of the asset sale, and we saw the government pick up the phone and give $30 million because of the asset sale agenda to protect it. We've seen it with Chorus, $600 million in excess costs being paid by New Zealand consumers. We've seen it with Sky City, we've seen it with Warners, and here we're seeing it again. Now, the fact is that this bill was very much a temporary solution. It's a transitory measure. It stifles competition in new business models, which I want to see new jobs being created. It ironically encourages piracy, online copyright infringement, because people say the disability community, and this is what we heard on the Select Committee, Ms Watkins, it's going to encourage piracy, because if the only way you can see a film is in a cinema, say a Westfield cinema, and you perhaps have a disability and you can't actually visit a cinema, it's going to turn to a torrenting or file sharing site.
Order.
It stifles current cultural participation because it only says this is the one way you can see this content for 5 months. And of course it is occurring in isolation because the government's delayed the much anticipated copyright review, ostensibly because of the Trans-Pacific Partnership. But I find it deeply ironic that we can't review our much out-of-date copyright laws because of the TPPA, but we can rush through legislation like this copyright parallel of films bill through a rushed process in Parliament. Look, Canada, Australia, the United Kingdom are all going through copyright reviews despite two of the countries having TPPA involvement. The fact is we need to update our copyright laws. They were written in a pre-internet age. They're not fit for purpose. They're not protecting New Zealand jobs, New Zealand industries, promoting innovation. We've got the ironic situation you can legally copy a CD to your iPhone.
I'm sorry
but not
to
a DVD.
interrupt the Honourable Member. Honourable Member, the time has come for me to leave the chair. This debate is interrupted and set down for resumption next sitting day. The People's House stands adjourned until 2 p.m. tomorrow, the 19th of September 2013. Haere rā, po mārie. Good evening.